Have you seen the motion that the defense attorney filed? It's not a proper motion. It doesn't say anything. So, all right, so shouldn't she be screened for indigency before you all represent her on the PR bond?
Good.
I mean, I think that's the proper way.
She just got.
All right, so if you'll get them to screen her, but what we'll do is, Attorney Sawyers, we'll hear your motion to withdraw. Someone from the state is coming down right now, so we'll hear your motion to withdraw. And if that motion is granted, then if you could go ahead and have someone screen her to see if she's indigent. And then if it's determined that she's indigent, then you all can appoint somebody, and then I can hear whatever motion you all want to hear. And what Attorney Elizabeth Russell's, this motion for a PR bond is not in the proper format. It doesn't have the proper, it's not presented legally, should I say. So I'm sure the state will have no objection to your doing it orally. Sure. All
Just
right,
to clarify,
yes.
just to clarify, you said the defense motion. Are you talking about that motion about the PR bond, or my motion to withdraw
Your motion to withdraw.
was not done properly?
No.
Oh.
Elizabeth Russell filed a motion for a PR bond, and it's not legally before the court. So this is what ended up happening, Attorney Sawyers. You filed a motion to withdraw. There was an issue with Miss Aaron's father interfering in your representation. When we were here the last time, he came forward, tried to be an attorney, and then he handed to his daughter her medical records, which she then handed to you. And then the motion to withdraw wasn't taken up because I think assumptions were made that he wasn't going to interfere with your representation. Then she didn't show up for court, even though she had noticed to be in court. And so a bond forfeiture was issued. And the court said that I would take up your motion to withdraw once she was in custody. And so that's where we are. So in between that time, managed to sign counsel, appointed her attorney, which technically is unethical because you are currently the attorney. And so that was interfering with the attorney-client relationship with her. So what we're going to do is, if you still wish to withdraw, I'll hear your motion to withdraw. Once I've heard your motion to withdraw, if I grant it, and part of my granting is going to depend on whether or not Ms. Aaron has any objection to your withdrawal. If I grant it, then you will be excused, and then they will have someone interview her for indigency, because that was not done either before an attorney was appointed. So that's where we are. So the state is coming down. I'll hear your motion to withdraw.
And just so that the court is aware, I had thought that this had already been granted because Elizabeth Russell reached out to me. And so I apologize for the confusion. I did not realize that I was still on the case.
Mm-hmm.
I had met with Elizabeth, and well, over the phone, we had a teleconference, but provided her a briefing of the case at her representation to me that she was appointed to the case. So I have communicated with her, and the only reason I wasn't there yesterday is because I didn't realize I was still the attorney of record.
No. It's absolutely not your fault. So that's fine.
I just didn't want you to think that I was intentionally not showing up. I guess it was just a miscommunication, and I do apologize.
Apology accepted, but not needed. I understand things happen. You've never before not appeared before court, and you've always been respectful. And I'm assuming you still wish to withdraw. Is that correct?
I think at this point it should proceed, but obviously I haven't spoken with Claudia because I thought it had already been granted at her request.
All right. Do you wish to still withdraw or no?
I do wish to withdraw, but I need to hear what her position is, obviously, because I haven't revisited the conversation since I was asked to withdraw the first time.
All right, just give us one moment, okay? Jody. You know what we could do? Yes. So they're gonna have her Zoom in, and we'll send you both to a breakout room so you can speak with her.
Okay,
All right.
that'd be great.
Deputy
Thank
Laura.
you.
Isn't Zoom fabulous? Who knew we would be doing this? All right, no problem. I have you in the breakout room. All right, thank you. All right. Let me do this and let me know. All right, are the parties ready to proceed?
We are, Your Honor.
All right, and are you still going to be asking to withdraw?
I am, by agreement of the client.
Okay. All right. Court is, I'm sorry, Ms. Guthrie, are you ready?
Yes, Judge.
All right, court is calling 2024 CR 0735, State of Texas versus Claudia Michelle Aaron. If y'all will come forward, never have parties announced for the record for the state
Daniel Escobar for the state of Texas.
and for the defense.
Jody Sawyers.
All right, and are you Miss Aaron?
Yes, ma'am.
All right, Ms. Sawyers has filed a motion to withdraw. State, do you have any objections to that motion to withdraw?
No, Judge.
And do you have an objection to Ms. Sawyer appearing by Zoom?
No, Judge.
All right, Ms. Aaron, do you have any objection to Ms. Sawyer's appearing by Zoom?
No, Your Honor.
All right, do you have any objection to her withdrawing?
No, Your Honor.
All right, and Ms. Sawyers, what are your grounds for seeking to withdraw?
Yes, inability to communicate effectively and breach of attorney-client contract.
Right, and that ability to communicate effectively, is that due in part to Ms. Aaron's father?
In part, yes, but not in whole.
Okay. All right, then the motion to withdraw will be granted to the clerk. Could you hold her motion to withdraw for me, please? All right, then you are excused. Thank you, Ms. Sawyers.
Thank you, Your Honor. Have a good day.
All right, you too. All right, so the next thing that needs to happen is then she needs to see, we need to see if she's indigent or not.
Yes.
And
Judge, I have pre-trials on their way up here and we're having a screen trial, 1702.
all right, thank you. And how long would that take?
I'm assuming it should take more than 10 or 15 minutes once they get here.
All right. All right, so Ms. Guthrie will go off the record, and if you could just be available, they say this is going to take 10 or 15 minutes.
Yes, Judge. Can I have the gentleman's name that just spoke for my record?
Yes, James Bethke, Director of the Managed Assigned Counsel Program.
It's Betke, first name James, and he's Director of the Managed Assigned Counsel Program.
Thank you.
All right, thank you.
I'll be here, Judge.
All right, thanks.
Just have a seat.
Deputy Laura have been watching this.
I've been thinking about it. My fiance Bailey, she's not really into horror movies.
Mhm.
I'm a pretty big horror movie fan, so I might have to wait until it goes on streaming and watch it whenever she's not around.
So are you gonna watch Deliverance?
Well, wait, Deliverance? The old one?
No. Bashan and Deputy Laura have been watching the new Deliverance.
They're like, "You Deliverance? When did they do that?"
Oh, it is not. It's not the Deliverance with,
It's not the.
no, it's not that one.
Okay, make sure, because I was about to say, that's a weird one to remake.
No. No, it's the one that's on Netflix,
Okay.
which I'm passing. I'm gonna pass.
Judge, how are you gonna survive the apocalypse if you can't even watch that?
I don't need that. I don't need that to survive this apocalypse. I just need to know what the rules are. Deputy Mejia, you know Gremlins. I'm the one who would have followed all those rules. You never would have had a Gremlin movie. The first thing I would have said, Dad, why are you bringing this home? Shouldn't we take this back?
They're so cute though. Just feed it, just get more. They're so
Mhm.
cute. Beautiful. It was so cute.
Yes. But then when that boy was being lax and follow the rules, Gizmo was like, oh no.
Gizmo.
I tell you what, I never would have got them wet. I'm like, Gizmo, you need to be out of the bathroom, taking a shower. Absolutely not. Midnight snack, not for you, buddy. And then I never watched The Quiet Place.
No,
Pretty good.
it's actually a good movie. One and two.
I was like, did I want to invest in that? And then now they have the recent one, and everybody's saying you should watch it because of the cat. So I don't know. Are they?
Yeah, they are. Unless you get a whole-
Yes. And those are the best. Oh no, I'm good. Hi, how's it going?
I'm good. How are you?
Great.
Good.
Oh, well, she won.
May I approach?
Yes. All right. So it needs to be determined if she's indigent or not.
Okay.
By, and then there's going to be a request for a PR bond, correct?
That's correct.
All right.
Hi,
Yes,
Aaliyah, nice to meet you.
Yes.
Hi.
Okay.
So if you all will interview her and let me know.
All right, sounds good.
All right. Thank you. Thank you. Oh, she can be interviewed here. Yes. Hello.
You gotta excuse me, I've been working, so
Oh, no problem.
clothes kind of raggedy,
No.
but I'm not ugly.
No.
I want to say thank you. You don't remember, do you?
No.
You remember, right? Do you remember me? I had dreads.
Ah, okay.
You remember?
Yeah.
I just want to say thank you.
Oh, you're so welcome. I really appreciate that. How you doing?
Trying to get in the path,
Mm-hmm.
but it's so overcrowded.
Okay.
And
Well,
I'm
you know,
not-
you just got to keep pushing and stay on the path.
I had Avery Salterwood dealing with it. Look me up, Lamont Curry.
No, I remember you. Stay on the path. But I remember you with your dreads. Yeah,
Hey, you was
Lamont,
my-
I remember you. Your attorney was Robert Porter. Yeah, I remember you. So I'm telling you, you got to stay on the straight and narrow. I'm sure I told you
It's
last time.
overpopulated.
No, it's not.
There's so many people trying to get on the straight and narrow. So I'm like,
No,
I
you
might
gotta
as
get
well-
on there because I remember you, and I remember that you had a jury trial. The jury found you not guilty, but here's the thing. With your history, your minimum is 25 years prison. So even though that path is crowded, you better get on
How
it.
you remember that?
My mind's a steel trap. Why do people think my mind is not? But Sean, they think I'm joking when I say my mind is a steel trap. Your minimum is 25 years prison. And if it's a state jail felony, you're looking at 2 to 20 because you're a habitual. But if it's anything other than the state jail facility, if it's state jail felony, if it's a third-degree felony, your minimum starts off at 25 years. You're not eligible for probation from a jury, and you're looking at 25 years minimum. So you have to ask yourself, staying on the straight and narrow, it's crowded. Do I try to get on that path, or do I get off that path? And it's 25 years of my life worth not being on that path.
I was thinking about jumping off that path.
You better not. Texas does not play. 25 years. And how old are you? Because I never asked you that before. How old are you?
How old do you think I am?
Now, we're not playing those games.
Okay, 45.
You're 45.
Yes.
If you do 25 years, guess what? When you get sentenced to 25 years, they are not going to release you at half your time because they're going to see that you're habitual. You're
Okay.
probably going to end up doing 20 years flat.
So
And
that
then
I
you'll
could-
be in your 60s. And maybe in your 60s, you'll find the right path because you'll only be able to sit on the
so
front
you
porch.
said I'll be walking with a wheelchair or a
Maybe not.
walker,
And then
cane.
maybe, or maybe you'll be in a box. They give you a pine box at the prison when you don't make it out. If somebody doesn't claim your body, they'll give you a pine box and find a place for you. And I will tell you this, the jail, there's overcrowding at the jail, but guess what? They're still open for business. There's overcrowding at the prison, but they're still open for business. So good luck to you.
I just want to say thank you.
Oh,
Okay.
you're welcome. And look, and I just put you back on that path.
Yeah, because you got a vision, put
Oh, I have,
intimidation,
no,
you put everything in my eyesight. Maybe I needed this, but I want to say thank you.
Oh, you're
Okay.
so welcome and stay on the right path. And call Robert Porter.
Where he at?
Yeah, he didn't even,
Is he here? He here
no, he's
today?
not here today, but just call him on the phone. He's in the, I know they don't have phone books anymore, but I'm sure you can look him up.
Okay. Can I get a dab, Judge?
I don't do daps. They don't allow
Can I
it.
get a peace sign?
Peace. All right. Have a good day. Why do people think I don't, I do. All right, whenever you all are ready. Where did, there you are, Renee.
Hey, Judge, good morning.
Yes. Are you all ready?
Yeah, yes, Judge, and we probably need a little bit more time to maybe file something after the hearing, but we're ready.
Okay. All right, and I'm assuming you all are going to be asking for a bond.
That's correct, Judge, yes.
All right, and Ms. Russell did not file the motion properly. Not only the content of it, but the fact that she filed it was done improperly. So, State, are you going to have any objection to Mr. Munoz making an oral motion?
No, Judge.
All right. Miss Aaron, if you'll come down. All right, so we're basically starting at 0 because Miss Sawyer's, she was just allowed to withdraw. The motion to withdraw was signed. So there's no interference with any other attorney-client relationship because now my understanding is that you've been appointed, Mr. Munoz.
That's correct, Judge. I know that the MAC office vetted her and she does meet qualifications for indigency, and she may have some substance use or mental health issues that we're looking to explore, Judge. So to my understanding that's the case, and I was notified that Ms. Sawyers was previously retained but did file that motion to withdraw, thus bringing her, Ms. Aaron, up for counsel, Judge, in the public defender's office. Withdraw, thus bringing her, Ms. Aaron, up for counsel, Judge, in the public defender's office is happy to step in and represent her in this matter.
All right, we're going to go on the record. Court is again calling 2024 CR 0735, State of Texas versus Claudia Aaron. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Renee Munoz.
And are you Miss Aaron?
Yes, on your.
All right, and we do have the court reporter by Zoom. I'm assuming nobody has any objection to the court reporter appearing by Zoom.
No, Your Honor.
No objection from the defense.
All right. Mr. Munoz, you have an oral motion?
Yes, Judge, if I may, with the court's permission, we're asking for a PR bond, personal recognizance bond. Judge, in this matter, it's my understanding, she does not have a lengthy criminal history. She's of a young age, and it's a nonviolent offense, Judge.
All right. State?
No objection, Judge.
All right. And I understand that she has pending misdemeanors.
Yes, Judge.
And-
I believe 2 of them.
And what are those misdemeanor cases?
I believe it's a resisting arrest, and I'd have to check on the other one.
All right.
No, Judge, the only one I see is resisting arrest. When I look her up, I just cases,
All right.
You know what court that's out of, Penny?
County Court 6.
Just Harris.
All right. And so what bond amount are you requesting, counsel?
We're asking a PR bond in the amount of $1,000 be issued, Judge.
All right. May I have a whiteout, please? If you all have one. And State, do you have any objections to a PR bond?
No, Judge.
All right, the court is going to set your bond at $6,000. The court will grant your PR bond. Now, with regards to the fees that are associated with the PR bond, would you like to address those?
Yes, Your Honor, if those fees may be waived, please.
All right, any objection, State?
No, Judge.
All right, there will be a waive fees. Now we need to address the drug issues. Miss Aaron, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Claudia Aaron.
All right, I'm going to ask you some questions. It's not about this case. So, in the past, and I know it potentially could be current, but for purposes of this case and not getting into the facts of this case, I'm going to ask you about past. So what is your past usage as it relates to drugs?
I started consuming at a very young age to help deal with my mental health.
Okay.
Around the age of 13, I first started consuming
And what did you
but-
consume?
marijuana, and it led up to Xanax abuse and stimulant abuse.
And what type of stimulants?
Cocaine and methamphetamines.
And have you ever had a mental health diagnosis?
Yes, yeah.
And what is your diagnosis?
Major depressive disorder, PTSD, and generalized anxiety.
And with regards to, I'm sorry, any other questions?
No, Judge.
Okay. And do you have private insurance or no?
Yes, I do now.
Okay. And with regards to this case and the facts in this case, was there anyone else with her? Does anyone know?
No, Judge.
No one was with her?
No, Judge.
So she was by herself?
Yes, sir.
Okay, all right. It appears to the court that she needs inpatient treatment.
Your
Does she
Honor,
have,
with respect to that, we would ask if she could be scheduled for an interview for potential outpatient first, Judge. It's our understanding that outpatient is a less restrictive setting, and I've done with specialty courts for a little bit, and I've seen the case managers and the judges in those specialty courts talk about starting off with the least restrictive means, and if that doesn't work, to move up to more restrictive means. Namely because if she doesn't need, particularly the assessment doesn't reflect her needing the inpatient, and she goes in there, it could be more damaging than her starting in at less restrictive. So I'm asking if we can get her evaluated to see her level of needs. I'm not a social worker or LCDC or master social worker, Judge, so we're just asking for just her to be vetted through that to see what she may need from a licensed professional. I don't purport to say that I'm a physician or I know anything about chemical dependency use. I try to learn and absorb as much as I can, Judge, but I think that's why the professionals are hopefully there to
all
assist
right,
her.
have you been into inpatient treatment before?
Yes, I currently went on June 22nd of this year.
Mhm.
I've been clean off of hard substances since December 1st of 2023, and I've been sober from alcohol since June 23rd of this year.
All right, so you said you went in inpatient on June 22nd.
Yes, Your Honor.
When were you released from inpatient?
I was released on Monday.
So do you feel you need to go back to that facility?
No, Your Honor.
All right, and when you say you were released, did the persons at that facility release you?
Yes, and they have me in intensive outpatient programming at the moment.
All right, and who is that with?
It's with Windmill Wellness Ranch.
And what does that outpatient treatment look like?
It's 3 days a week, any days I'd like from 9 o'clock to 12 o'clock for the next 4 weeks.
And what do they do?
We specialize on processing emotions and just constant drug testing and just kind of regulating me back to a normal lifestyle instead of like a heavy, intensive inpatient program.
And how often are they doing drug testing?
At the moment, I have one. I don't know how often they'll be doing it for the next 4 weeks.
All right, and this outpatient treatment, how long is it?
It's for the next 4 weeks.
And what if you need more treatment in outpatient than that? Have they given you an idea of what they would do?
Yeah, I could definitely always ask for more time and help if I really am struggling and need it.
Any other questions?
So just one brief question, Judge.
Yes.
So Ms. Aaron, upon you, if you're able to be released on your own personal recognizance, upon you don't have to pay, would you be re-entering that substance facility, the outpatient to get help?
Yes,
And that would be for when again?
the next 4 weeks.
Okay, no further questions.
All right, this is what the court is going to do. The court is going to order outpatient treatment with Windmill Wellness Ranch, and that's through your insurance.
Yes.
And so what I'm going to say then is to be paid by Miss Aaron. If for some reason something happens with your insurance, let your attorney know, come back to court, and we'll do a different outpatient treatment.
Okay.
And counsel, she's going to have to do a release to pretrial services so they can make sure that she's actually attending.
Okay, yes, Judge, no problem.
All right, so there's going to be outpatient treatment with Windmill Wellness Ranch with treatment classes at a minimum of 3 days per week.
Yes, for 3 hours a day for 4 weeks.
And there is going to be random UAs,
Yes.
and that is going to be, yes, I know wellness, they're doing their UAs, but these random UAs are going to be through pretrial services, and I'll ask that they waive fees.
Yes, Your Honor, thank you for that, and I'll explain that to her as well.
And then I'll ask for a referral to Center for Healthcare Services if she has a private provider with regards to that, then she can do private provider. So I'll say referral to Center for Healthcare Services or with a private provider.
Yes, Your Honor.
All right, is there anything else you need to be successful on this bond?
No, Your Honor.
Defense, is there anything else she needs?
Nothing further, Your Honor.
Okay. And let me just add one more thing. After conclusion of treatment with Wellness Ranch, I'm going to order 120 sober days. I'm sorry, 120 sober support meetings in 120 days. And I will tell you, those are NAAA meetings. Sometimes people are feeling a certain way about doing these. They're like, why do I have to do this? It's so much work. But then what I've discovered and what people have come back and told me is that once they get into the routine of going to those meetings, they really enjoy it because they get a chance to meet other people who are in the same situation that they're in. And then the next thing I know, they're doing retreats with them and it becomes a way of life. So it's going to be 120 sober support meetings in 120 days. All right. And then I'm going to set you to reappear in this court for this case. And let me look at my calendar. All right. We'll come back on October. Let me see, your 4 weeks. We're going to come back on October 7th. All right. Is there anything else?
Nothing further from the defense, the judge. We appreciate your attention to this matter.
All right. And if y'all will have a B page pulled, because otherwise the fact that I've just said it on the record is not enough. It needs to be in writing. So if y'all will pull that for me and I'll put it in writing.
So I just go to the clerks in the back and ask for the B page, judge, and they should be able to provide that?
Yes.
Okay, will do.
And I'll give you this reset form.
Yes, ma'am. No, I'll have
And-
her execute that as well.
All right. And this will be for discovery. Yeah. Thank you. All right. Thank you, Stephanie. We are done.
Okay, thank you, Judge.
All right. Have a good rest of your day.
You too. Bye-bye.
Bye.